Division 1 is now in session.
You may be seated. Good morning. Today is February 8th, 2024. This is the time set for oral argument in our case number CACV 230363 Dominguez versus Dominguez. Out of respect for counsel and to avoid any embarrassment for anyone in attendance in the courtroom, please make sure your cell phone is on silent. Each side is allocated 20 minutes for oral argument, although you are not required to use all your time. If appellant wishes to reserve a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium. The clock on the podium reflects the total time remaining. As you know, these proceedings are being recorded and are live streaming. The video will be posted on YouTube following today's proceedings. So I ask that when you present, you please state your name and the name of your client when you begin. Unfortunately, the weather has prevented Judge Ferreira from being here in person today. He's listening to your arguments on the live stream and will be submitting any questions he has electronically to me, so we will have that. We've read the briefs, studied the record, and discussed the case in conference, so please keep that in mind as you present your case. You may proceed.
Good morning, Your Honors. Haley Saul Khalili for the estate of Magdalena Dominguez. The Honorable Judge Warner summarized the case well while addressing opposing counsel at the August 20th, 2021 oral argument. Judge Warner said, "You're saying that the statute says somebody can forge a deed, record it, and as long as she's not checking her county recorder records every few years, which almost none of us do, that is sanctioned, that the law will sanction that forgery. If the trial court's decision is upheld, Arizona will be sending a message to all forgers that if they forge a deed, record it, and as long as the person they're victimizing isn't checking their county recorder records every few years, which almost none of us do, that Arizona..."
Counsel, isn't that true only in one section of the statute? Doesn't one of the other statutes allow for or contemplate that if there is a forged signature on a document that, it wouldn't be valid?
Yes, Your Honor. I'm assuming you're referencing ARS 12525, which has a subsection B, which is not really a forgery exception, but a prerequisite to an owner bringing an action to eject someone in adverse possession. So that forgery exception is really a standing issue for the person who's bringing the claim in ARS 12525. If we were to apply that directly to ARS 12524, that would mean Magdalena, who passed, is the one who would have to be the forger. So it's the reverse in our situation. It's
Counsel, there is no exception for a forged deed in 524. I understand that you argue that the deed is forged, and there's certainly evidence in the record from which one might draw that conclusion. But the deed on its face looks valid. And under 524, the person who claims to be the owner has 5 years to make a claim, and it's way past that time. So aren't we bound by 524?
Your Honor, I would argue that forged deeds are void on their face, and although
Well, but you can tell. If you look at the deed without taking extrinsic evidence about whether it's valid signatures or not, you wouldn't know that it's an invalid deed, arguably so.
Your Honor, yes. Looking at it and not just looking at the deed on its face, looks like it's valid, but having a forged signature on a deed makes it void on its face. And the U.S. Supreme Court and 20 other jurisdictions in this country have ruled that forged deeds are void on their face, despite the fact that you can't tell with your own eyes that the deed is forged. And in Baker versus Stewart Title and Trust of Phoenix, this court held that constructive notice of facts from public records is no defense to fraud. So just because Renee recorded the forged document, putting the world on constructive notice, this court has said that that's not a defense to fraud and cannot constitute a recorded deed.
So how on its face can you tell that it's forged?
It's a forged signature. So if you compare the signatures of the forgery and the true signature, you would be able to tell it's forged on its face. And we have a handwriting expert who...
That's not the definition of on its face. When Judge Foster and I talk about on its face, we're talking about the four corners of the document. And on the four corners of the document, you can't tell, can you?
Your Honor, you're right. You can't tell by just looking at the four corners. But in interpreting ARS 12524 in the one case, the most prominent case it has in Quality Plastics versus Moore, that was directly relating to a legal description and flipping a 5 and a 0 on a legal description. That's much different than somebody forging a signature and recording it and saying, well, it's been 5 years, and especially when the person who's forged the document prevented the victim from discovering that fraud for over 17 years.
And how was that? Magdalena discovered the deed by going through her son's papers. How was that hidden?
Well, Your Honor, that is a question of fact that unfortunately we didn't get to resolve at the trial court level. She did discover it in 2020. She timely brought that claim as soon as she found out. Renee handled her finances and accounts. She had control over those accounts. It's still a question of fact of whether she paid the property taxes out of her own funds. She had direct access to Magdalena and Isidro's assets and accounts. She did her tax returns, and so there's still questions of fact that need to be resolved in the trial court.
And so there are several elements to fit 12.5 to fit within 12.524. Are you conceding that this is a city lot? You did below.
Sorry, what was the question?
That this is a city or town lot.
Oh, yes. So, yeah, this isn't in a city or town lot,
Well,
and we...
But you conceded that below.
Well, we didn't discover it until after filing the notice of appeal. I do concede that. But in Resolution Trust Corporation versus City of Scottsdale, this court said that appellate courts have discretion to consider questions of a general public nature for the first time on appeal, especially substantive law issues not affected by questions of fact. And this is a matter of public record, not a question of fact.
But it was conceded for purposes of this litigation up until this point that it was a city or town lot. So how can we reverse the trial court judge when you conceded that fact that if you had contested that below, who knows what would have happened?
I agree with you, Your Honor, and that's why I think this case is especially relevant for us, because it is a substantive issue that would prevent the application of 12.524 in this case. And although it wasn't discovered, we didn't concede it, but we didn't contest it. I agree with you.
If that is so, then we don't need to reach the more difficult issue. So I'm confused why you're arguing the more difficult issue than the more simple issue.
Well, I agree it's the more simple issue and would resolve the case. So it would resolve this issue. I was touching the more difficult issue first because it's kind of the elephant in the room, but I agree that that would be dispositive of the case.
So you said that, the court, our court, can address things when they're of a general public nature. How is this a general public nature? It's private property.
It is private property, but I think especially when it's going to affect the outcome of the case, the Court of Appeals has discretion to consider it for the first time on appeal. And I think the important note is that it's not a question of fact that we took away from the trial court. We lost on summary judgment, so we're not taking anything away from the trier of fact. It is dispositive. It's the first factor in 12524, and it's not in a city or town.
But was there some way you could have raised this with the trial court once you realized the new fact?
Yes, we didn't realize it until after we filed the notice of appeal, Your Honor.
Is there some way you, once you realized the new fact, that you could have gone back to the trial court to fix it, so to speak?
I suppose we could have. I'm not sure that would have made a difference in the trial court. He ruled basically just flat out that we were past the statute of limitations, and I'm not sure if it would have made a difference. We could have, I'm assuming, yes.
Thank you.
Yeah, thank you. So secondly, if this court finds that ARS 12524 applies, the statute of limitations should be equitably tolled. In Porter v. Spader, this court reiterated the common law principle of equitable tolling, stating that courts have recognized that as a matter of equity, a defendant whose affirmative acts of fraud or concealment have misled a person from either recognizing a legal wrong or seeking timely redress may not be entitled to assert the protection of a statute of limitations. Here, as discussed, Renee cared for Magdalena and handled her finances, including submitting her tax returns until 2020 when the fraud was discovered. Renee's...
What was the trial court's ruling on the issue?
I don't believe that he made a specific ruling on the issue. He obviously assumed that the equitable tolling would not be applied in this case and that she should have discovered it. I am guessing when it was recorded.
But you argued equitable tolling below.
Mm-hmm. We did argue equitable tolling below, yes, Your Honor. So for that reason, because Renee's affirmative acts of fraud misled Magdalena from recognizing the legal wrong within the 5-year statute of limitations period, the statute of limitations should at the very least be equitably tolled. And third, our last issue is the right to pursue a quiet title claim never expires while a cloud on title exists. Even if this court affirms the trial court's ruling granting ownership of the Buckeye property to Renee, the estate is still entitled to a damage award under 33420A. The court in sit-in ruled that the sale of a property to a third party has no effect on a property owner's ability to litigate claims based on documents wrongfully recorded during the time that the property owner held title. Because this lawsuit was brought to quiet title to the property based on the forged deed, which was wrongfully recorded during the time that Magdalena held title, the estate is entitled to treble damages for the loss of the Buckeye property if the trial court's decision is upheld. In conclusion, Arizona has not conclusively stated a position on forged deeds and their effect on statute of limitations. However, I urge this court to follow the U.S. Supreme Court and the 20 other jurisdictions in establishing that forged deeds are void on their face and not allow forgers to use ARS 12524 as a safe harbor. If forged deeds are void on their face, 12524 cannot apply to the forged deed in this case, and thus the trial court must be reversed. Regardless of whether forged deeds are void on their face, the appellee has failed to establish that the property is a lot in a city or town, or that she has paid the property taxes out of her own funds for the requisite period. But even if this court finds that 12524 applies, the statute of limitations must be equitably tolled because of Renee's fraudulent behavior and concealment that misled Magdalena from discovering the forgery in time. Lastly, if the trial court's decision is upheld, the estate is entitled to a damages award under ARS 33420. Thank you.
Thank you. Counsel?
Good morning. My name is Lance Broberg with Tiffany and Bosco on behalf of Apolli Renee Dominguez. I will jump right into one of the issues that was asked, which concerns the whether or not this property exists within a lot or a lot within a city or a town. This is not an issue that was simply not raised at the trial court level. This is an issue that was specifically addressed and on which the appellant took a specific position. In fact, if you look at the index of the record on appeal, there is a specific discussion about whether or not this existed in a lot. So the court concluded in index of the record 60. There is no dispute about the first and third elements, the first being whether or not this lot existed in a city or a town. How did the court get there? It wasn't based on oral argument. It wasn't because there was nothing in the briefing. It's because the response to the motion for summary judgment, index of the record 48, page 10, lines 9 through 11, provides as follows. Accordingly, while Magdalena does not dispute that the properties in question are lots, as the term is applied in ARS section 12-524, there are significant factual disputes regarding elements 2 and 4 of 12-524. So this is not a waiver for lack of raising it. This is an issue that was actually raised, addressed, and they did not dispute it.
So were you under a mistaken impression that it was a city, town, or lot?
Your Honor, we haven't even investigated that because that issue only arose. There was a reference to it in the opening brief here in the factual recitation section, but the only time anybody has cited, quoted, referenced, or raised the issue was in the reply brief to this court, in which there is a link provided to the assessor's website pointing to this particular page. That's the only time this issue has ever been raised. That's the only time there was an argument that this was an unincorporated portion of Maricopa County. Again, from our perspective, this issue could have and should have been raised at the trial court level. It was raised at the trial court level. The appellant now affirmatively said that they did not dispute that this constituted a lot for purposes of 12-524. That waives the argument.
Well, I've got a couple of questions about that. Is the placement of a lot within or without a city or a town, is that something that a court can take judicial notice of? And then my follow-up question, if you could answer both, is if it will turn out by a proper investigation that it is actually not within the city or town, how do you apply a statute that factually would not apply?
Your Honor, I don't think that the court can, and I will concede that I'm not somebody who's a professional when it comes to city plannings. But when you're talking about a lot that exists within a city or a town, I think there is evidence that would have to be taken and considered to determine what constitutes a lot. I think we would have to look into what constitutes a lot, what constitutes a city or a town. Does it receive the benefits of the city or the township? Does it have an agreement with a neighboring city or township, which is common for some of these unincorporated areas, for example, with respect to fire services and otherwise. So I think there's more that would have to go into that analysis than a simple, was it raining that day or was it not raining that day, in which we can take judicial notice. That did not happen here. And again, the fact that this comes up the first time in a reply on an appellate briefing is not just too late in the game here. I think the fact that it was raised, and remember, it's not just a motion for summary judgment. There was also a motion for reconsideration. And then there was subsequent litigation for more than a year, because that motion for summary judgment was resolved in August of 2021. The case continued for another year before it was ultimately resolved, and then there was time afterwards where, as Your Honor indicated, a Rule 60 motion could have been filed, something saying that new evidence has been discovered. None of that was ever done here, and so the first time we see anything about the assessor's site
Mr.
is in the
Broberg,
reply.
I'm going to counter that a little bit. Judge Ferreira has mentioned that this was raised in their motion for summary judgment, specifically on page 6, lines 20 through 21 of the motion for summary judgment.
Then I'd refer you to, of our motion for summary judgment or their response? It has to be their response.
Their response, I believe.
If you turn to page 10, lines 9 through 11, that's where they ultimately make the statement that they do not dispute that this constitutes a lot for purposes of the application of this statute. So again, from that perspective, the dispute is over. Whether we were going to investigate whether this constituted a lot, whether or not there's vagaries concerning whether or not this constituted a lot within a city or a town, that dispute ended when the parties effectively stipulated to the fact that this constituted a lot for purposes of this statutory application.
So the actual fact in the fact in the world may be different, but for purposes of this litigation, your argument, this is a judicial fact that everyone is stuck with.
Once it has been effectively stipulated, then yes. And I would treat that similar to the fact that there's a lot of allegations about forgery in this case. First, we dispute those allegations of forgery, but for purposes of this argument, that's not appropriate. There's no reason to raise that. You assume for purposes of a summary judgment that in fact it was a forgery, and then we move on from there. For purposes of our discussion and our argument today, the parties have stipulated that this statute applies, that this property was a lot as applied in that particular statute. I think that's the end of the analysis for purposes of this court. Otherwise, what we have is somebody literally years ago stipulating this statute applies, this property is a lot. The parties then litigate to conclusion, and only on appeal, in a passing reference in the facts in the opening brief, and then with a citation to the assessor's website in a reply brief, they effectively take back all of their stipulations, the agreements, and everything upon which the trial court relied and the parties litigated.
So, Mr. Broberg, if we take your position, and, you know, a forged deed is discovered 100 years later, are you then in a situation where a bona fide purchaser has a problem 100 years later because it's a forged document?
I'm not sure that I necessarily understand that. The concept is, let's assume this is a forged document, and here we are 20 plus years later. Under this statute, the court does not take consideration of the quality, whether somebody had good faith or bad faith when executing the documents that were ultimately recorded. And that's consistent when you look at not just the Quality Plastics case, but there's 3 cases in Arizona that talk about this: Nicholas, Sparks, and Quality Plastics. All are cited. Quality Plastics cites to Nicholas, and they both cite to the Sparks case. And in all of those cases, the underlying deed was void. It was void, whether it was a void because there was an improper separation of the parcel in Quality Plastics or something else. But the court said it doesn't matter. We don't look at the quality anymore. The only consideration.
So why isn't this deed void?
For the same reasons that Your Honor has mentioned. When you look at it, it has to be void on its face. As long as it has all of the other elements, and this is spelled out specifically in the Sparks decision. And in Sparks, it specifically says, when the statute speaks of a recorded deed as one of the elements of title by adverse possession, it specifies the kind or quality of title which is necessary to support it. It means a deed not void upon its face, which, tested by itself, has all of the constituent parts knitted into that kind of an instrument. Not that it is a conveyance, but that it purports to operate as a conveyance. So that's all you look at. You look at the 4 corners of the document. If it has the constituent parts to operate as a conveyance, then it satisfies that prong of 12-524.
Did any of those cases address a forged document?
No, there are no cases in Arizona that deal with the forged document.
So then why should we rely on them?
Because those talk about just what that particular element means. And that particular element means if it has all of these elements, it is valid on its face. If you were to look at the forgery and say, but what if it's forged? You are adding an additional element. And that's why juxtaposing 524 and 524.
But aren't those cases really about, situations where, there's a number missing, or, maybe the plot number isn't exactly right, but it's really clear what was meant to be conveyed. I mean, isn't that really what those cases are talking about, rather than a situation where somebody has forged a document and tried to make a transfer that was not valid.
Yeah, take it to its extreme. If I drafted up a document right now that purported to transfer title, complete forgery, every single word, every single letter on that document, every single signature, if that document is recorded, does it satisfy the criteria that set forth originally in Sparks, adopted by Nicholas, and then adopted by Quality Plastics, as a recorded instrument that purports to transfer title? It doesn't even have to effectively do it. It has to purport to transfer title. The answer is yes, it does. 100% forged document satisfies those prongs. What we're doing here is trying to read that subsection B from 525 into 524.
And I don't disagree with you. I'm just questioning, what you're asking us to say, because your words, we're assuming that this is a forged document, and now we're saying that it wasn't discovered for 20 years, and now that it's discovered, we just sort of ignore that it was forged, and we move forward. That result just doesn't really seem just.
I feel like I'm talking to Judge Warner, the trial court judge. He asked that question. He asked me specifically, when was the last time you checked title to your home? My answer, not recently, but it will be recent after this. But as we can appreciate, it's not our job to determine whether or not we like a statute. It's not our job to determine whether or not we think we should rewrite it. This is a statute that's existed as long as Arizona has, and these cases that we're citing, the Sparks and Nicholas and Quality Plastics, they're not new. The statute hasn't been changed. If there needs to be a subsection 5, so a fifth element that says, except in the case of forgeries, the legislature can do that. It's not for this court to take that action.
Yeah, counsel, the estate would have a better argument under 525.
Correct.
Why would the legislature allow the forgery to get you to show how it's done, or forgery exception in 525 when you're at 524?
If I could predict that, I might switch my positions. I can't speak to why the legislature specifically included that in the 525, which really deals more with an adverse possession type of a situation. But with respect to this, with 524, and what you're looking at here is it's not a situation where somebody simply goes and records something and secretly, surreptitiously waits, and then all of a sudden gets the property titled in their name. There are notice requirements. So first, and this goes to one of the other issues that's been raised here on the equitable tolling, this is not secret. This was a recorded document recorded in 2003. So first, now we have constructive notice. So the owner of the property should be aware, according to the law, which is interpreted constructive notice forever, as far as I know, should be aware that that happened. But then you have 5 years worth of property tax payments. If you own the property free and clear, you're not making payments, you're not receiving receipts, or you're receiving a receipt, not making a payment. So there's 5 instances separately of notice. If you have a mortgage, then your mortgage lender is making the payments most likely, and you're getting a refund because somehow the property taxes have already been paid. So there's 5 separate instances of notice. So it's not as though this is a statute that simply says anybody can record something, and as long as they hold on to it, nobody notices for a period of 5 years, it becomes their property. And this also doesn't prevent other types of claims that might exist should they timely and appropriately be brought. What we're focused on here, though, is simply one of those statutes where you look at it. The interpretation of this statute and the language of the statute is clear, and it has been consistent throughout Arizona statehood. You have 4 elements. Is it a lot within the city or the town? Did they pay the taxes for the 5 years? Does it purport to claim an interest in the property, which is not disputed? And then I'm skipping the last one, but the recorded deed, the one we've been talking about the whole time, whether or not it was a valid recorded deed on its face. If
Mr. Broberg, would there ever be a time when what would have to be on that document or not on that document for it to not meet the standard in Quality Plastics and Sparks and the other case?
If it doesn't have identifying criteria, for example, for the property, if it doesn't identify who the purported buyer is, if it doesn't have the indicia that looks like A is conveying the property to B, and here's what the property is.
So do we never get to a situation when there's a question as to whether the document is valid?
I think you can.
How?
Well, for example, in the Quality Plastics. So Quality Plastics looked at it, and they had some discussion, and there was some analysis about, if you recall, the issue there is in the meets and bounds description of the property. It was 150 feet wide, but in actually drafting up the purported deed, they transposed the number, so it was 105 feet. And so there was a bad description. The Quality Plastics case then goes and looks at that and says, well, you're supposed to look at these monuments. You're supposed to figure out what the actual property was. Could you actually tell what it was? And so it said, even in that case, while it fell a little bit below, it was still clear what was being discussed. So it still satisfied an attempt to convey property from A to B in that particular case. So the sufficiency of the property description in that case, the sufficiency of the parties involved in that case, other aspects of a normal transfer can be considered. Whether it's a forgery, though, simply adds something entirely new. It adds something completely different, and what it would do is it would allow parties who claim an interest in a property to completely circumvent all of the rules. To say, listen, I'm going to reopen a quiet title claim on this case by simply arguing that something on that particular deed is false. Not something that you or I would look at if we went to the recorder's office right now and pulled the deed. Not something you and I would look at and say, you know, this is confusing. This is not valid. I don't know what property it is.
But this is what I'm struggling with your argument is, if a deed is forged, how do you ever get to court on that and get that litigated if the document on its face is valid and we're just supposed to take it at its face? How do you ever get to challenge whether it's a valid document and or potentially void?
Within 5 years. You have to do it within 5 years.
So as long as it's within 5 years, your position is you can still challenge that.
Correct. So what 520...
But how does that comport with your position with Quality Plastics, where you say, as long as the document on its face looks good, like, we're good to go?
Well, Quality Plastics only applies because the 5 years had long expired. So in the Quality Plastics, what happened, there's a lot of machinations that happened beforehand, but ultimately it was a tax lien and a treasurer's deed issues. Somebody buys the treasurer's deed for this 45-foot chunk of property, pays that for an extended period of time. And the court in that case says, listen, all of the underlying transfers were void. That there shouldn't have been a 45-foot parcel. There shouldn't have been a tax lien for that parcel. There shouldn't have been a treasurer's deed for that parcel. And it shouldn't have been sold to this individual over here. But that individual's been sitting there holding title by a deed that was recorded and has paid taxes for 5 years. So the statute of limitations is run. And my argument would be the statute of limitations here is the same as any other statute of limitations. If I clearly breach a contract, but I wait 7 years to bring that claim, or the other person waits 7 years to bring the claim, it's gone. It doesn't matter whether it's fair, just, equitable, right? The statute of limitations says you have to bring your claim or forever hold your peace. And that's what this says.
So 524 is just a very particularized multi-element statute of limitations. So if neither owner or the estate raised or filed suit within the 5 years, she could go to town on how forged the deed is, and as such it would stand in the way, even if the deed would look fine on its face.
Yes, it's a very specific statute of limitations for a very specific circumstance. And so this statute of limitations applies when you're talking about recorded documents. So we're talking about the entire world is on notice about the ownership of this property. Let's assume that Renee and her now late husband, Jose, sold the property to me 10 years after 2003. And I have a right to rely on them and acquire this particular property. And it's my property now. At the end of the day, when you have a recorded document, once it's been recorded, filed, once tax payments have been paid, there is a right to say, if you haven't challenged that within a set period of time, then you don't have the right to challenge it, at least on a quiet title action. And that's all this focuses on, is on a quiet title action. No different than an adverse possession. You have 10 years under the statutory adverse possession scheme. If it's been 11 years before you notice that somebody built a house on some section of your large, expansive property, it's too late. It doesn't matter whether we like it, whether it's fair, whether they've paid, whether you've paid property taxes on that section. If you waited too long, you don't get to raise the quiet title claim again. In this particular case, 2003, it was recorded. There's no dispute that we paid the property taxes. I know that's nuanced, and they're saying, well, we don't know where the funds really originated from. There's nothing in the statute that requires that kind of analysis, and there was no evidence presented to dispute it. That's my time. Never got to the 33-420. So.
Actually, one final question from Judge for your, assume the deed is obviously forged on its face. Do we get the same result here?
No. If the deed is obviously forged, and you know, obviously specifics are going to be interesting on what obviously forged is, but I don't know how it could be obviously forged other than if there was some kind of I don't need to go down that. If it is obviously invalid on its face for a forgery or anything else, then I think that's different, because then it doesn't satisfy the prongs. Anyone, third party, your honors, myself, who pulls that document up and looks at it and says, this is not a valid, complete deed, then it doesn't satisfy that prong.
Thank you.
Thank you.
Counsel.
I want to first go back to the city or lot issue and say that although the estate didn't dispute it at the time in the trial court in our motions for summary judgment, it's because we didn't discover it until recently. So it wasn't that we conceded, yes, it's in a city or lot. We just didn't dispute it at the time because we didn't have all the facts.
Well, but aren't you bound by that? Because that's true in any litigation. There may be subsequent discovery that might show that your understanding of a fact is wrong, but you're bound by that. The trial court has to rule on what is before it. It can say, well, maybe down the road this will be different. So, you know.
I agree with you, Your Honor. Yes, that it should have been brought and it should have been discovered, but it wasn't, and it is dispositive of the case. If it was an immaterial fact and it was a question of fact at that, then I agree it's waived. But it's a substantive area of law that would be dispositive of this entire case and is a prerequisite to the statute even applying.
But your colleague points out that they didn't do any investigation on this. How do we know for sure that it is? At the very least,
well,
this needs to be resolved in the trial court. You had an avenue to do it by way of Rule 60. You didn't do that.
Well, yeah, I agree. We didn't. Rule 60 motion must be brought, I believe, within 60 days of a final judgment, and we discovered it after the fact. And we filed this notice of appeal. We were not going to bring it, frankly, but I believe that it is important, and I believe the Court of Appeals has the discretion to hear this for the first time on appeal because it's not a question of fact. The Maricopa County Assessor's parcel map is public record, and the appellee could have just as easily looked that up as well, and they didn't either.
But isn't that your responsibility to find out?
I mean, they raised it as a defense, so I would argue that it was also their burden to prove that it isn't a city or lot. And separately, in quality plastics, the court said the purpose of the description requirement on a deed is to give notice of the adverse claim. The court said this form of notice is essential to 12524 since the statute does not require actual visible appropriation of land. But later, as I mentioned, in Baker versus Stewart title, this court held that constructive notice of the facts from public records is no defense to fraud. So I'm not sure how the constructive notice argument works in their favor. Just because she recorded a forged document that put constructive notice to the world, that's no defense to her forgery. And I'm not sure that that's the message that we want to send, that if you make sure that the person you're forging doesn't discover, and where you have a fiduciary relationship at that, and you can ensure that she doesn't discover, she's elderly, she doesn't even speak English, doesn't know how to use the Maricopa County Records online search, if she prevents her from looking those things up, that's fine. That Arizona will say, forgery is okay, 5 years, that's it. And I still argue that...
But hasn't the legislature already said that? by not including it in the statute?
Well, I still argue that those statutes are apples and oranges. 12525 is about adverse possession, and it is a standing issue for the owner bringing an action to eject the adverse possessor. In our statute, 12524, Renee would be the adverse possessor. There's no exception to her in 12525. The exception is directly to the owner bringing the action. So we would be having to say Magdalena was the forger in 12524, but that's not at issue here. So the 12524 says an action against someone having a recorded deed. To have a recorded deed implies that you have a valid deed, and a forged deed is invalid.
But doesn't the case law suggest that the recorder is going to record a deed that seems valid on its face? That's what all the cases we've been talking about are. So the recorder records it, but at that point, you know, there's an obligation for someone to understand what got recorded and whether there is an action. That's the whole purpose, to give 5 years statute of limitations to bring a claim to quiet the title. And so I guess I'm struggling a little bit with your differentiation. I mean, the legislature could have said anything in the statute. They could have, you know, contemplated fraud in this situation, but they didn't. And so we're left with what they put in the statute.
I agree, Your Honor, and what they put in the statute does not include that anyone claiming under a forged deed is entitled to the benefits of this section either. So I think it's a matter of interpretation, and other jurisdictions, an overwhelming majority of this country has ruled that forged deeds are void on their face, basically like a blank piece of paper. They constitute a nullity, ineffectual to pass title. The United States Supreme Court says it's ineffectual to pass title under a forged deed. So I would urge this court for the first time to say that forged deeds are void on their face and not allow forgers to escape just because they've made it past 5 years, that they're able to escape that reality. And lastly, the appellee admits that we're dealing with a forged deed here. That's even more reason to equitably toll the statute of limitations in this case, and that's all I have, Your Honor.
One question from Judge Fiora, but isn't there a bad faith component for adverse possession? I mean, so the legislature, didn't they change that for 525 and not for 524, and that evidence is a conscious intent?
That there's a bad faith requirement in 12525 and not 12524. Yes. I agree, but I think adverse possession, it's naturally there's going to be a stricter requirement. That's taking someone's property out open and notoriously. 12524 is dealing with someone who's dealing behind the covers and, you know, being sneaky and forging a document. I think it's not needed in 12524. It's a recorded deed means valid, and a forged deed is invalid. And Arizona Central Credit Union, this court has held that a forged mortgage document is totally void, and it prevented the plaintiff from bringing an action to enforce that mortgage document. So I think the same can be said for forged deeds.
Thank you.
Yeah, thank you.
Further? Thank you, counsel. We'll take this matter under advisement and issue a decision in due course.